Okay, so this panel is really all to discuss human rights practice. So not just human rights in theory, but how do we actually use it in the real world, and how do you build a practice at the bar in human rights? As you will have seen, we're joined today by Gronya. Gronya's already on the screen. She's a fellow member of my chambers at Garden Court. But more importantly, she's the Vice Chair of the Bar Human Rights Committee and also the Chair of the Irish Lawyers Association. Yeah, good morning. Well, afternoon. Excellent, you made it. We're also joined by Jude, who, congratulations. Recently, the recipient, as I understand it, of the Chamber's junior barrister.
Something.
It's not a gain, actually, Jude. The very recent recipient of the Chambers and Partners Award for the Human Rights, Civil Liberties Barrister, effectively of the year. So congratulations, Jude. I'll get there eventually. Otherwise known for his sourdough and baking skills, which I understand he's been doing this morning. Hence the outfit. We know. Okay, so this panel is really to introduce the students and other people to what it really means to have a human rights practice at the bar. And perhaps the very first thing that I think perhaps needs to be said is there's no real such thing as having a pure human rights practice. But from my perspective, at the very least, human rights really pervades almost every area of work, and then it's pulling it out into your practice areas. But I'm certainly turning to Jude. How would you describe having a human rights practice, Jude?
For me, it just means having quite a lot of fun. I act in basically the whole array of human rights. So I do media law, which is when newspapers and broadcasters want to challenge orders which interfere with their freedom of expression. I do prison law when prisoners are being badly treated. I act in inquests when people have died at the hands of the state. I bring civil claims for damages against state bodies, but the most part of my practice is judicial review, where if the government have done something unlawful, then I step in and try and argue against it.
Excellent. Thanks, Jude. And Gronya, can you tell us a little bit about your practice and what human rights means for you?
Well, I agree with what both Joe and Jude have said, in that it does, when you say human rights, it really encompasses a very wide array of practice areas. So I also act in judicial reviews and civil claims, and also in some sort of appeals in the Immigration Tribunal and in the Court of Protection. And my practice really is immigration, health, children's rights. So very similar types of litigation to Jude, but perhaps with a slightly different focus, but it's still very broad. And I think that's one of the main messages for the students, is that there's a lot of different types of work that you can do that both applies human rights law and also applies the principles of human rights. In other words, acting for individuals, usually in relation to the state.
Excellent. And just a little bit about me. I'm also at Garden Court Chambers. My practice encompasses a little bit of what Jude does, a little bit of what Gronya does, and then some more crime on the side, effectively. So a serving of each, in short. My practice that engages human rights tends to be primarily in the sphere of children and criminal justice, so more of the fair trial aspects, those types of things, and then some inquest inquiry work also. So hopefully we've got a broad spectrum of experience here on the panel today. So if you've got any questions, and I should have said this at the outset perhaps, pop them into the chat. Just make sure that in relation to the chat that you've clicked onto the session heading. Otherwise, you'll just be speaking to the wider group. Unfortunately, we won't see those. We're fortunately joined today by Chris, who's going to pick up, I hope, on some of those questions as we go through, which will be wonderful. Okay, so what drew you guys towards a human rights practice, and then how did you develop your specialist areas? Perhaps starting with you, Gronya.
I really wanted to practice in human rights really from as soon as I wanted to come to the bar. Like Jude, I'm from Northern Ireland, and I do think that probably gives us an enhanced perspective on aspects of the rule of law and the importance of the judiciary and litigation in establishing and protecting individual rights. So I think that was probably one of the factors for me. And I didn't have a very clear idea of the precise type of law that I wanted to do the bar and actually still don't have a very specialist practice in the way some people do. And I think that that's, I mean, it depends on different people, but certainly I think that's the strength to have a broad range of areas. And so I think it's one thing I do like to say to students who I find are often really nervous when they're applying for pupillage about not having one area that they know they want to spend the next 40 years of their life practicing in. In my experience, it's not like that. You don't have to have that. But obviously, as you go along, you will become more drawn to certain areas and some work will follow you. But I think having a broad practice, particularly in this area, is probably a very good thing.
And for those students and individuals that joined our earlier session on the publicly funded bar, that was certainly one of the overarching key messages and themes that came through, which was effectively, you may think you also have an interest in one area. To actually practicing in it, you may suddenly find that you're far more interested in a different area. So keep your options open. Don't close down those doors. And Jude, your practice is very varied. It's very broad. Obviously, public law really runs through it as a theme. And what do you have to say?
I just say it's such a treat, because whenever I was a wee kid and I wanted to come to the bar, I remember going to these events and just seeing all really, really posh white people talking to me. And now it's the clear message that in order to succeed at the Human Rights Bar, you need to be from Northern Ireland.
You're overrepresented, Jude. You're overrepresented.
Me and Grania, I think we knew each other long before we were even at the bar.
Yeah.
From back in the day. Yeah, I mean, practice just develops. It's a wonderful, wonderful treat that something comes your way, and you, if it's interesting, you do it, and then somehow you get known for that, and then you get more and more and more of that type of work. I came from a very political background in Northern Ireland, where my parents were both on the left, both very interested in ensuring that people's rights were protected. My dad was a big trade union official. My mum was also very interested in those areas, and discrimination and breaches of human rights were something that we lived with in Grania when we were little. And so that gave me a desire to practice in this area. I have to say I'm a wee bit unlike barristers who go, I want to be a barrister. I wanted to be a human rights barrister. I didn't want to be any other kind of barrister. I think it would be a wee bit boring being from doing kind of other kinds of straight law. I can see someone else from Northern Ireland in the chat, which is exciting me greatly. But to answer some of those questions, which I can see coming through as well, I before coming to the bar, I did an internship in the same as Grania did in politics. I worked in politics for a political party for a period of time in Northern Ireland, doing press work for a political party, and I saw that politics was all well and good at a kind of a macro level, but I wanted to be able to input on people's lives in a more individual way. And so I didn't do unpaid internships in human rights work. I did politics, and then that gave me the advocacy experience to transfer into human rights work.
So, sorry to jump in, but just on that point, we've had a couple of questions about sort of whether unpaid internships are helpful and what sort of experience you should do if you're thinking about a human rights practice. Grania and Jude and Joe, what would you suggest?
I don't know if you want to go first, but I mean, from my perspective, becoming the human rights bar is probably a wee bit different to other areas of the law, because people come to it a wee bit later in life, and they come to it having had life experience in areas in which human rights are at the cold face. So it could be in charity work, it could be in politics, it could be in some other form of advocacy, standing up for people's rights. And the more of an expert you are in fighting for people, i.e. standing up and arguing and trying to persuade someone, and in a specific area, be it benefits law, be it crime, be it housing law, then those are things which really can transfer into a practice at the bar. I think personally those are much more interesting than doing a 6 months unpaid internship in the United Nations or whatever it may be.
Yeah, I think we're all acutely aware of the fact that actually unpaid internships are something that is only available to a subset of the population and demographic, because ultimately you have to be in a relatively privileged position normally to be able to undertake such work. And I think there's a societal move actually away from unpaid work in that regard now, even within charities and NGOs. The real difficulty, however, is that ultimately when it comes to applying, you need to have some form of experience to be able to tick those boxes and demonstrate that you've got an interest, but you've also got the skill or the experience. And I think, unfortunately, they do still have a place ultimately. And I think it would be misleading for me to say that they don't have a place when it comes to your application or anything else. But certainly in Garden Court, I think it's fair to say that we are more likely to put greater weight on long-term voluntary work at a Citizens Advice Bureau over a 3-month death penalty internship in the United States. And I say that as somebody that's started out with an amicus internship. I think, I think that the situation has changed in that regard, and we do what we really at Garden Court, what we're really looking for actually is a commitment to our social values and ethos. And I would imagine that is broadly the same type of approach that's taken at Doughty Street with applications. Yeah. It doesn't need to be unpaid work, but you do need to have that commitment because it's such an important part of our actual working culture and working life in chambers. It's the one thing that unifies everybody within our chambers. So again, it's going to depend on the type of chambers that you're applying to, the types of human rights work you want to do. Because of course, just bear in mind, actually, I've just realised on this panel to a large extent, the three of us are mainly claimant-based, actually. As a general rule, we are representing individuals against the state. But set against that, of course, there's a whole practice area which consists of individuals who mainly defend those claims and act for the state. And so you do need to have a slightly greater grasp of that. And chambers, to a lesser or greater degree, will either act in claimant work or defendant work. And I think, certainly from my perspective, when I came to the bar, when I was applying for pupillages first time round, in chambers of partners and legal 500, that distinction wasn't as clear as it perhaps ought to have been to me. So certainly I was applying to defendant-based chambers while really telling them in interview I wanted to do claimant-type work. It's not really going to go down quite so well, so learn from my mistakes.
I had the same mistake, and I actually remember calling Jude. I don't know if you remember, to tell him a couple of places I applied to, and he said, Grania, I don't think they're really the kind of places that you thought they were. And I was like, well, thanks, at least. Anyway, I think there was a mutual rejection, as I like to call it.
And then there are places obviously that do both. So basically just do your research is the answer, because otherwise you're going to fall down in either your application form or your interview. But it really is very broad indeed. And that's not to say that you shouldn't engage in defendant-based work, because of course that's just as important actually in articulating where human rights norms and standards fall and looking at the limits of such arguments, because they are not the solution to everything ultimately. And I think that's something that you learn very quickly in practice, is to draw upon other areas of the common law and the like.
Totally.
And try and get some experience. Sorry, Jode.
I can see a couple of questions coming in, picking up on some of the things which I think I've said. I'll just answer them quickly if that's all right with you guys. Dervla, basically coming from Northern Ireland, I decided that I wanted to practice in England because I went to university in England, and because you can specialise to a much greater extent in England. You can become a human rights barrister in England, whereas Northern Ireland, the bar tends to be much more varied, particularly at a junior stage. Also, having the support of a chambers around you means that work trickles down to you rather than having to actually go out and get work for yourself in the bar library, which is very individual. So you can then, once you practice in England, go back and practice in Northern Ireland as well. And speaking for myself, in the last week, I've been in the Northern Ireland Court of Appeal on Tuesday, the Liverpool Crown Court on Wednesday. I'll be in the Parole Board next week. I'll be back in the Northern Ireland High Court on Friday. And that's part of the joys of Zoom. I'll probably actually sit in this room the whole time, but you can practice in different jurisdictions. And then in terms of advocacy, Dervla, to answer your other question, a question that Hafs has asked as well, I actually think advocacy of any kind is important. The ideal, of course, is doing advocacy in a courtroom, because then you can show that you're already a barrister effectively. But standing up as an appropriate adult, which is something that I did the whole way through law school in Nottingham, or indeed working in women's aid or victim support, those types of organisations, is extremely helpful. One of my best pupils in the last few years is someone who worked for Macmillan Cancer Support, and she actually specialised there in going and acting in benefits tribunals to stand up for people who had cancer who were losing money, and she therefore was a fully fledged advocate by the time she started in the chambers.
Yeah, I think just to pick up on that point, but I think it very much depends as well on what your experience is within the organisation, whether or not it goes to advocacy, and just also be aware of the types of chambers that you're applying to, because the more traditional sets will be looking more for advocacy in the traditional sense of mooting and the like. I think certainly Dowd Street Garden Court have a much broader approach to those types of issues than potentially other chambers. So just be aware of that. And again, look very carefully at what your experience, you can leverage it into the various skill sets, because it may go to advocacy, it may go to conference skills, it may go to personal skills, it may go to commitment. So have a look at those aspects.
And I would just say on that point, I think it's really good to try and get sort of stuck into something, because I do see a lot of students who do one or two things here and one or two things there, and that shows a lot of variety, and that's good. But I think responsibility in an organization, or responsibility following a project through and learning from it, can be quite beneficial, and I think probably more beneficial than dipping in and out of a couple of quite standard things that may be on offer on the bar course or that are generally available. So I think being proactive and taking or obtaining responsibility in an organization or in a case, even if it's on a small scale, can make a difference.
Yeah, I'd wholeheartedly agree with you on that, Grania, in terms of the types of experience. If you see something with 3 weeks here, 3 weeks there, 3 weeks somewhere else, it can only take you so far, as opposed to a solid, 6 months doing some sort of part-time legal clinic for an hour or two on a Thursday evening, where you're really getting into a much greater level of detail. I just thought, how do you recommend finding out about the claimant defendants generally? And chambers try and sell themselves in every different possible area. Well, I think the best way to do that actually is to look at their often chambers will have a recent news cases page, and have a read through that and just look at who their barristers are representing in those cases, and that will give you a flavour straight away ultimately.
This is I think it's quite difficult, Kareem, because it's one of the things that chambers do, which is very cunning, is they'll say involved, and you go, Matrix involved in this case. You're like, oh, right, so who are we acting for? And it turns out they were acting for the human traffickers. Another chambers, One Crown Office Row, built up a really successful human rights blog called the UK Human Rights Blog, which is brilliant and a fantastic resource. But the barrister who ran it, who's now happily one of my colleagues, Adam Wagner in Chambers, really didn't have a claimant human rights practice. He now does, because he's in Dowdy Street, but in One Crown Office Row, it was predominantly defence focused. And so there is a certain amount of sort of code that you have to get used to. And what Joe says is entirely right. Actually, inquire into it a wee bit and see what their barristers are actually doing, and that will give you a wee hint. But as a broad scheme, Dowdy Street and Garden Court pretty much only do claimant work. Other chambers in the human rights sphere, be it Blackstone, One Crown Office Row, Matrix, Moncton, will do a greater spread of the two.
I've just seen another one. I had a mini pupillage at human rights chambers, but didn't actually get involved with the human rights aspect. Would the experience still be considered useful? Would it be worth keeping updated with their human rights practice? In short, the answer is yes. It's useful from the mini pupillage side of things, if nothing else. And certainly when it comes to application forms or CVs, getting an idea of the types of mini pupillages that you have often gives an insight into that actual individual applicant in any event. But frankly, mini pupillages are actually more useful for you potentially to either answer specific questions in an interview about why this set, if you've been there, or why you've ruled a practice area in or out. But yes, keep it there, keep it up to date, and go from there.
Yeah, I agree. Although I do think that mini pupillages and meetings become a real focus for students, and I understand why. And I think you do need to have a little bit of both of them. But once you've done a couple of mini pupillages, I think then you're able to say, look, I understand the bar, or I have some insight into working life and the realities of it. And I would then probably spend most of your time, especially for human rights work, on an issue that you care about, on working with an MP, on working with a local charity, on a little bit more sort of substantive human rights work, rather than people who've done 8, 9, 10 mini pupillages. I think there comes a point where you just need to say that you've done a couple, and then maybe move on to trying to gain some other experience.
I massively agree. I think the only thing you learn from someone who can do 8 to 10 mini pupillages is that they can live for 8 to 10 weeks free in London. Yeah. I mean, it seems to me that I personally didn't really get much out of any of the mini pupillages I did. I used to fall asleep in them, and I remember one occasion being in court, and the usher saying "all rise," and I was straightforwardly asleep, and he had to say it again, and the whole court was stood up, and I was asleep, and I basically don't do that.
Can I ask you a more general question, Jude? I mean, if you could put one or two key things that you think students should focus on if they're thinking about a human rights practice, what would they be?
Academic ability, just the ability to intellectually crunch through issues, spot deal with the detail, and commitment. And commitment can be having done this, worked in this area, believing in this area, and caring for this area, because at the bar you have to work very, very hard. And it's hard to work very, very hard if you really believe in what you're doing. And there's times when you lose a case, and it's very, very galling. And unless you're committed to the practice area, then you won't really succeed. So I think those two things for me are the most important things.
How about you, Sonia? What would you say about to that?
I just agree completely with you. I think commitment and sort of perseverance is the big thing. And the second point that I think is really important is being proactive, because I think I certainly felt when I was a pupil, and once I got pupillage and got through it, that all I would have to do would be to sort of work hard. But there's a big part of the bar is also taking initiative and developing your own practice and constantly making connections and thinking about new opportunities. And I think that level of being proactive, when you see that in a pupillage applicant, it certainly makes me stop and think. So have you set up a campaign? Have you taken an initiative, even on a very local level? It doesn't have to be, as Joe said, in the Caribbean on death penalty work, but that sort of, I suppose it's leadership or responsibility can make you really stand out, and also shows commitment and a certain level of get up and go, which I also think you really need.
I think also, if it helps, Chris, it's just not, it sounds very glamorous, human rights, the practice area, but ultimately it's a lot of hard work, as Jude has already said. And I think also it's long-term work, because you often aren't getting quick wins in cases. You're not dealing with a trial whereby you lose or you win, or those sorts of things. If you're looking at broader strategic challenges, for example, you're often doing those incrementally. You're going to have losses along the way. It's very rare that you go straight into an issue cold, so to speak, and win in that sense.
Yeah.
Again, maybe that's my experience, Jude, and Grania, not yours, but the reality is you're going to lose an awful lot, and you need to be able to actually lose in the right way. So you may be dealing with a case where you know you're going to lose, and you're actually looking at, right, what do I want from this judgment? What do I actually need to get out of this judgment? So children, very rarely will a court ever say anything. They will always say something nice about children and the approach to be taken and proceed with fairness.
Was that case that we did together?
In which case, yes, that's true. In which case, you're all very lucky because the tribunal is no longer there. I think that's probably a little bit indiscreet of me, but no, unless you're in that particular case. But even in that case, actually, the irony is we lost the case. It was a criminal appeal involving very young defendants with very significant learning disabilities who were treated more or less as adults in the trial process. We weren't representing them in the first instance. It was an appeal on joint enterprise and effective participation. But even in that case, we ultimately got out of the court at a very high level indeed. New procedures to be followed in the Crown Court in relation to those children and having children on trial, and comments about mandatory training for advocates with children. So you've still got something very positive actually out of it that we've built upon since then. But ultimately, again, very galling, as Jude would say, because it was one case that we ought to have won, frankly.
Yeah.
So I think that exactly what Grania and Jude have said in that regard. We're looking for resilience. We're looking for commitment. We're looking for all of those things, but you do need to have that good foundation there. And you need to be aware that human rights and civil liberties work, and chambers that undertake that work are highly competitive when it comes to pupillage applications. So you do need to basically sing from that page, unfortunately, and doing a sort of everybody will have relatively good academics. It's a must, I think, unless you can make up for it in a different way. Certainly don't rule yourself out if you don't. But then you're looking for other things in addition to that. You're looking for other things in addition to, your standard mini pupillages and all of those types of things, mooting, So really think very carefully about any applications, where the weaknesses are, and try to build on those, because you will be up against individuals who are excellent. In fact, the general quality of applicants across the board now is superb.
There's an interesting question here from Colleen, who says that she was hoping you could elaborate more on best ways to respond when asked in a pupillage interview about whether you would act on the part of the government in a human rights case. She says, my inclination would be no, but worried this comes across as naive, closed-minded, or as being labelled an activist lawyer. What do you say about that?
It kind of depends who's asking the question. The reality is, as a barrister, of course, the cab rank rule applies, and if you hold yourself out as an expert in an area of practice and you have sufficient time and it's properly paid and a case comes your way, then you have to do it whether you like that client or not. But how that works in practice is that if you're in a specific practice specific chambers, the government will probably not approach you to do a case unless they think that you're going to do it in a specific way. I suspect that if you're asked that question in a pupillage interview, it's from a chambers that probably suspects that you might be a wee bit of an activist lawyer and probably wants you to demonstrate that actually, yes, I do want to be in your chambers, which does both government and non-government work. And obviously you will answer in the ethical way and say, of course, I'm very interested in advocacy and the rule of law and ensuring that everyone receives a fair trial regardless of their vulnerabilities or circumstances. Yeah. Joe, you agree with me?
No, I do. I think that if you answer no in certain places, then that's basically, you may as well have just not bothered making the application in the first place. It will be straight in the bin. And as I already said, hopefully you'll learn from our mistakes in that regard. I think that's right. But I do think equally, I mean, we all act mainly in terms of claimant work. I also do a lot of criminal work and I defend. And you often get asked those sort of questions, you know, about how do you defend somebody's guilty? It's a similar type of principle, isn't it? Or if you're looking at the prosecution in the state. But ultimately, it's really important, actually, that you have good people on the other side, that you have people who are independent, people who understand the law, that people who don't make these arguments. And it's really important as a consequence. And the rule of law, as Jude has alluded to, is obviously huge, is obviously best served by having those best advocates on the other side. And I think that's how I would approach that question, to be perfectly frank, is that the reality is that somebody has to be on the other side of a human rights claimant argument. It may be a totally spurious argument, or it may be an argument which, if you followed it through to its natural conclusion, actually has huge repercussions and ramifications that are not present in that claimant's case, but they do across the board. And often there are, competing resource issues and all those types of things. So I don't think it's actually as black and white as perhaps we'd like to believe it is. Actually, I think there's a lot of shades of grey there. And so I certainly don't close off those avenues, because you can do an awful lot of good work too. And a lot of the sets that do predominantly defendant work, actually, as they get more senior, you find that those individuals are instructed in some of the most interesting cases from a claimant perspective.
Yeah, I agree. I would be sensible about it, and particularly in terms of where you're applying to and who's asking the question. But I think you can also be honest. I mean, if you're more interested in developing a claimant practice, I think you can say that. And with many of these pupillage interviews, it's how you answer the question, how you structure it, referring to sort of both sides, etc., that can get you the marks rather than the sort of position you come down on. So I think referring to things like you said, the cab rank rule, the rule of law, and equality of both on both sides, etc. And I also think from a human rights point of view, it is changing. It used to very much be the individual against the state, but because of positive obligations, particularly in areas like trafficking, we are seeing that a lot more work is taking place, certainly at local government level and sometimes at central government level too. So I think how you structure the answer and the weight you give to the different arguments can sometimes be just as important as what side you ultimately come down on.
There's another really interesting question here. A great question. How long has it taken you for you to get where you are now in your career? But within the context of your practice, what's been the most challenging period, or perhaps the most challenging thing? Jude, how about you?
I missed a wee bit of that question. I think Are you guys all there? Can you hear me?
Yeah,
Yeah.
I can hear you.
Sorry, I think my kids are watching Paw Patrol up the stairs. So
Yeah, the question was, how long has it taken you to get where you are now, and what's been the most challenging period in your career?
well, despite my youthful visage, I'm actually really old and past my best, and it's taken me all this time to get where I am. I mean, obviously, I appeared in the world a fully fledged barrister when I was in the womb, and I was already arguing Supreme Court cases at that stage. It takes time, and it's not linear, and it doesn't develop quite the way you want it to. And sometimes you look back after a year and you wonder if you've actually made any progress in that year, and you can't really tell until quite a long time has passed and you look back and you can see how things are different now. I think the most difficult time that I can remember is, I'm trying to remember the exact year. I think it was summer 2014. So I had my first little kid who was about a year old. I had 3 back-to-back cases, all with quite significant difficulties in terms of the personnel involved. One was a QC who was very difficult to work with. One was a solicitor who was very difficult to work with and has since been struck off. And another was an NGO that was quite difficult to work with. And we were on holiday, my wife and I and our little girl, and we had to come home because the demands were too much, and I had to just keep going. Had to go home and continue working. I'm not sure my wife has really forgiven me for that since. And that was a real difficult time, and it was galling, and we lost all 3 of those cases, and some of them were pro bono as well, and you were still getting a lot of grief for doing it. And so it can appear like, actually, if you were to ask, if someone were to look in, they would have said that I was doing 3 very glamorous and exciting cases, but they were all very difficult in individual ways. And it's what Grania says, it's about grit and determination to get through that and to bounce back, basically.
Grania, how about you?
Well, I just think I agree with Jude. I think it's workload sometimes, no matter, even with the best planning in the world, sometimes things are out of your control. Court decide when and what is happening, and you are there is, I'm afraid, always going to be a last minute nature to things. So I think workload can really be a challenge. And I also think personalities, I mean, we're all self-employed, but there still is a couple of working together and teamwork and managing different personalities, the client, the lay client, your own professional team. But I do think that the early couple of years are quite hard, and I think getting pupillage, and it's such a steep learning curve, your pupillage year and a couple of years afterwards, it is quite tough. But I think once you can sort of get through those first couple of years, I won't say it gets easier, but certainly it's less of a extremely steep learning curve. So I do think those early stages can be hard. You're finding your feet really at the bar as an advocate, and the whole thing can take a while to get used to.
If I could just throw this in, did your career develop as exactly you wanted to, or effectively did it take hold of you and develop you in the process? Which way did it work?
I think weirdly, it's for me, it's the former. I mean, if I'd known when I was at the stage of all you guys in the chat room that this was going to be my practice now, I would have been punching the air with joy. And I've been really lucky just to have developed a practice which gives me exactly what I want. It's really exciting. I get to do really fun cases. I get to argue against really clever people. I get to work with brilliant people like Grania and Joe. It's just a brilliant life, to be honest. I'm gonna start crying.
I think it's kind of both. I think I agree with Jude that I love what I do, and that I feel lucky and to be in the position that I did always want to be in. But I also think you can have that sort of goal or sort of plan, but you also have to have a degree of being flexible and going with what happens. And I think it's a sort of a mixture of the two.
How about for you, Joe?
Yeah, I think that's right. I think you take opportunities, but you are also to some degree in control of where you go and where you end up, provided that you put in the work along the way, actually. And hard work really is part of it, actually. And putting yourself out there, seminars, all those type of things, making yourself into a specialist in an area, All of those help in terms of which direction your career will go in. But also just being nice, frankly. You can be the most awful opponent in the world and you'll get an awful reputation. And it doesn't take much to just be nice. And so I think, people do back then. I certainly remember my opponents who were nice, and I've brought in different people from chambers as a consequence of the cases who are more incompetent, but also you can get on with. It doesn't mean you can't have a good fight in court. You can, but you get on with them. In terms of my career trajectory, I was very fortunate in coming into the bar. I'd been in the US for 5 years and came in at a reasonable level, and it went off very quickly. But I think I've certainly shared the challenges Jude is sharing. I'm on maternity leave at the moment, and obviously baby, breastfed, all the rest of that sort of jazz. I'm being completely open and upfront about it now. And owing to COVID, as a consequence of COVID, unfortunately, all the cases that were due to complete prior to maternity leave are all now effectively coming to fruition. So I think since I've had the baby, I've done something like, I think, 3 substantive judicial reviews, an inquiry. Next week I've got a conjoined appeal and judicial review, and balancing all of those as well as other commitments is challenging. There's no way around it, and trying to juggle those things, and you always feel like you're letting down one side after the other, and the mum guilt is real, and I imagine the dad guilt is real too. So there's that. But having said that, you just do the best that you can, don't you? And you get through that. But I think the bar is becoming much more open to those things. I think that's a message I really do want to get across now, is that chambers are very supportive and the courts are very supportive, actually. If you flag up the issues, there is a greater recognition of the need for a work-life balance and well-being, and hopefully that will mean that a lot of you coming to the profession now won't perhaps have your lives taken over to the extent that us three certainly were previously.
There's a really good question here, I think, within the context of the wide variety of work that is human rights, which is it perceived negatively for advocates to be emotionally affected by their work? Grania, what do you say about that?
I don't think that that's the case. I mean, there's obviously a degree to which you have to be emotionally separate from your case in the presentation of it in court to some extent. But I think it's naive to think that you won't be affected by some of your clients' experiences, particularly clients that you're working with for a long period of time. And I think being affected by their experiences can be important. I think it can be a big motivating factor. It can help you understand them more and therefore present the case in a better way. But obviously it is something that you have to be mindful of and make sure to sort of keep in your mind in terms of your own health and well-being. And I think it's something that I think people mainly, I know with some of our junior tenants in immigration, so in immigration detention centres and with people being put on flights that they don't manage to get off by way of urgent injunctions, it I think is a particular challenge in that area. And I think you just have to talk about it, have support in place, and just acknowledge really the reality of the work, how high stakes it is, and that you're doing the best that you can, and to some extent be able to draw a line around that. But I think pretending that you're not emotionally affected or denying that you don't have to do that. And certainly I can think of a number of cases that I was very affected by.
I agree with that. I mean, it would be inconsistent with what we've said all along about commitment if we were to say that it's frowned upon to be emotionally engaged in your work. I mean, the fact is where we do these areas of practice as claimant human rights practitioners because we care about our clients. That's why it hurts so much when you lose, because you know that you've let someone down. The other side of the coin, though, is that sheer emotion isn't going to get you through when it comes to actual work as a barrister. You have to be able to persuade a judge, and a judge doesn't work on the basis, certainly at the higher levels of the appellate system, on the basis of sheer emotion. They care about, they want to be able to, they want to care about the issue and how it affects people on a policy basis and all the rest. And so you can't just assert things emotionally and hope to win. You also have to do the work and be able to present something in an intellectually coherent and emotionally disengaged way so as to be able to persuade people.
Yeah. Joe, what's your view?
No, I agree. I think it's actually really important, though, to build your own emotional resilience. because the thing, certainly depending upon your area of practice, the things that you will come across are actually deeply, deeply traumatizing on occasion. I practice also in crime, and it's a little bit like Gronya said in terms of some immigration work. And the things that I have seen, and the things that I discuss, and the things that I deal with on a daily basis, for example, child sexual abuse. Unfortunately, people film these incidents, and sometimes you have no choice, but you've got to see what's actually on those films. Those types of things will stay with you forever, and they scar. They really do scar, and they will pop into your head potentially at completely random times. And you need to be able to deal with those aspects, and you need to be able to put them effectively to one side. So emotional resilience is really important from my perspective. I think that's why the strides that have been taken in well-being are really, again, significant actually within the fields that we practice in. As Jude has already said, you're not going to win a case based on an emotional submission. It's just not going to happen. You're also not going to do your client justice unless you can view that case with objectivity. Because in absent that objectivity, you're not going to identify where the weaknesses, the pitfalls are in your argument, and where actually the winning arguments are. Yeah. So ultimately, you're simply not going to be operating at the level you need to operate. And I'm pretty hard-nosed about that aspect actually. And there will always be cases that will stay with me. But the following day, you're going back into court for yet another case, and you need to be able to commit yourself to that case. But you also just need to give yourself that time to process as well. So you do need to have strategies in place. And I'd advise all of you to have a little think about that. And what works for you, what works for me will not necessarily work for somebody else. But look at how you'd manage those stress levels, because they do come from it. You're not arguing, for example, about, I don't know, the cost of tyres in a monopoly and rubber. You're dealing with real people's lives, and that makes it all the harder. But it's also what makes it really worthwhile and rewarding. And so, the negatives ultimately for me, and I think I'm sure for Gronya and Jude, are outweighed by all those positives and the work that you're doing.
If I can just pull two questions we've received together, one from Amal and one from Mariam, that really, does good academics mean you went to Oxford and Cambridge? And do you need an LLM or a PhD to do it to get into human rights practice?
The answer to both questions is no. I think certainly I've now been in 3 different chambers, and all 3 of them have treated all degrees the same, regardless of what university you went to. If you get a good mark in a degree, but your university isn't called Oxford or Cambridge, then it's still a good mark in a degree, and it's evidence of academic excellence. If you haven't got a good mark in a degree, then you may consider it helpful to go and do an LLM and to get a good mark in your LLM, and thereby demonstrate a degree of academic excellence. I mean, to look at Rebecca's question there, a 2-1 from Oxford is bloody brilliant, whatever way you want to look at it. There's no requirement to do an LLM or a PhD in order to build a human rights practice. What matters is the things that we've talked about. But that said, because you're a barrister, you're dealing with a weird mix of street fighting, because you're against people, it's adversarial combat, but also intellectual ability. And because what you have to do is you have to look at a case, you have to see what the issue is, you have to know what the answer is, you have to filter through all the rest of the stuff, all the rest of the authorities, and you have to be able to present it coherently. And that requires intellectual ability, whether you like it or not.
Yeah, that's really helpful. Ronnie, what do you say?
Well, I agree. I don't think going to Oxford or Cambridge or having a master's is necessary at all for the bar. But all I would say about the master's point for Rebecca asks into building an international human rights practice. And I do think that it's not necessary for the bar, but I do think it's quite important for international human rights, particularly if you are thinking of a broader career. So certainly for most UN positions now, I think in the international human rights field, they do expect a master's. So I think for international work, not for the bar, but generally for international human rights, doing a master's is something which is increasingly becoming the norm, but not everyone can afford it. Not everyone has the time or personal circumstances to be able to do it. But I think if you have a broader interest in international human rights and are able to do a master's, I think it can be a useful thing to do to practice in that area in particular.
Yeah, I would just add that a lot of chambers are now moving to a blind marking process. So actually the name of your university or institution is stripped out. There's quite a useful pupillage report that's come out from 5 Essex Court. They do one every year. It's really helpful. It's very transparent, and they do the same thing. So it's effectively a little bit like the ICCA's application process for Barristers, actually. That blind marking process is in place, and so it doesn't make any difference, actually. I think the only thing I would say, though, sorry, Jude, is that if you are applying to more traditional quasi-commercial chancery sets, then I think it does still make a difference, unfortunately. When you look at the career paths of most of their junior counsel, that's going to be part and parcel of it, but it certainly doesn't mean it's the only way in. Again, it's looking at what else is on that application form, what else can you offer in that respect, and can you build it in a different way? If your academics aren't good, you need to be looking at how do I excel and pick up marks in a different section of these skill sets. Sorry, Jude.
I was going to say, like Joe, that 5 Essex Court pupillage report, which came out the other day, should be required reading for all of you. I mean, they are, let's be frank, wrong-uns who only act for the police and do bad things. But their pupillage report is absolutely impeccable, and I only wish the human rights chambers like mine were anywhere near as advanced in terms of the transparency and clarity of what they're asking for and what they suggest in terms of how you approach applications, in terms of attention to detail, typographical errors and all the rest. Goes for every single chambers, whether it's a police chambers or a non-police chambers.
Harriet asked a very practical question, actually, that she hasn't got a human rights module on her degree, but are there any textbooks or other books that you would recommend that any budding aspirational human rights lawyer looks at?
I didn't even do a law degree, and I didn't have the opportunity in my conversion course to do a human rights module, and frankly I don't think you need to read textbooks or seminars in order to become interested in this practice area. I was very radicalized as a young man by reading works of philosophy and politics, and more recently there's lots of very helpful books which have been written by practicing barristers which explain some of the deficiencies in the justice system, which are also very helpful to read in order to give you an understanding of how these things work. People like Helena Kennedy or The Secret Barrister, for example, are all pithy and clear and accessible.
Yeah.
Yeah, I agree. I don't think doing a module if you're not able to do a module in your undergraduate degree, it's really not the end of the world at all, and I wouldn't worry too much about it. I agree with Jude that reading those kind of practitioner textbooks is a really good place to start, and generally on the Human Rights Act in the UK, I think Conor Garrity has a couple of Hamlin lecture books which are really short and quite good value and a really good tour de force of the Human Rights Act in terms of how it was implemented and its main principles. And it's actually not a bad read, she says, while maintaining the veneer of being cool.
And Vadu, to answer your question, which is on the same lines, I don't actually know what these online human rights courses run by foreign universities are. There's a certain amount of people who like to try and cash in on this, and the reality is, if you have the academic ability, which you can demonstrate through whatever you've done at university, if you have the advocacy experience and if you have the commitment, then you're going to be very well placed to do this job, whether you've done a fancy human rights module from a foreign university or not.
And I've just seen a very specific question, but Gron, you might be able to help a little bit about this. You do some education work. It's, do any of you work in education law? I know Gron certainly does. I don't know if you do. You may well do. And the right to education or academic freedom. And is there much work available in this area? I suspect the latter part, in terms of the right to academic freedom, there's less of that type of work, but there is a whole area of law devoted to education law.
Yeah.
Yeah, I mean, education is, I think, probably one of the fastest growing public law areas, and obviously there's schools work, so special educational needs, safeguarding, and a lot of policy challenges to that, and also in higher education, a lot of appeals processes and JRs. I mean, on the academic freedom point, probably there's a bit less, but there have been interesting challenges in recent years, including to the prevent strategy, and certainly there's judicial review work in the area. And I think education is I think people with a background in higher education who really understand the sector would be very well placed to work in education and judicial review work in particular.
It perhaps demonstrates just how broad a human rights, civil liberties practice can be, because there is all of that work in education, and it often overlaps into community care, responsibilities of local authorities on a much broader level. So it becomes very interesting, actually.
That's completely correct.
I think that brings us to the end of this particular session. I'd just like to say thank you to everyone for taking part, to Jude, to Gronya, to Joe. It's been really helpful, and I can see from the responses we're getting, everyone thought so. So thank you so much. Enjoy the rest of your day.
Take care.
Thanks, guys.
Thanks. Bye.